everyone. All right, we'll get started. Good afternoon, everyone. Thank you for joining us here today. My name is Tim Hennessy. I'm lead counsel for Mr. Trezell West. Associated counsel with me will be Joshua Fleshman. He's not present at this moment. Here with me also is Alexia Torres-Stallings. She represents Ms. Jacqueline West. And associated counsel for Ms. Jacqueline West will be Ms. Fatima Rodriguez, here present to my left. This will be the only time defense counsel will be addressing the media and making statements about the case until after the trial. We won't be answering any questions here today. We won't be discussing any facts of the case. Our clients, we've spoken to them about this. They're behind this. They understand our need to getting our side out. Last week, our clients, Mr. and Mrs. West, were arraigned on an indictment of 5 counts, including second-degree murder, and that came as a result of a grand jury convene. There's been great confusion we've seen about the difference here between a grand jury and a trial jury, and the two of those things could not be more different. First, the standard of proof is lower for a grand jury. They need to only determine probable cause, which is one of the lowest legal standards our system holds. They also do not require a unanimous vote by the jurors. The prosecution also has broad discretion in determining how to proceed and doing so by way of indictment. The grand jury process lacks a crucial and important role of our criminal justice system, and that is the accused and their counsel being present during. There's no opportunity to cross-examine any witnesses, and it is basically ran by the district attorney. This is to the detriment of the accused, as evidence of a speculative nature has a way of integrating itself into this most secretive of all legal proceedings. On the other hand, a trial by jury, they must unanimously agree on the issue of guilt or not guilty. And there you have the highest standard of proof, which is beyond a reasonable doubt, and it is a proceeding done in open court. The state's comment and reliance on this "we have proved to a grand jury" is mere rhetoric. It's used as an insurance to bolster a lopsided indictment. Comments such as this have no place in an actual court of law, where it is 12 individuals who unanimously decide the outcome of this case based on this highest level of burden of proof, which is beyond a reasonable doubt. Statements that have been used by the Kern County District Attorney in her press conference tend to invoke a tidal wave of emotion towards finding guilt, whether substantiated or not, and this will taint a local jury pool and could deny our clients a chance at a fair trial. It's odd that the office held their press conference, made a series of comments which both mis- and disinformed the public, then the following day came and requested a gag order to stop the defense from having an ability to make similar comments. This action is disingenuous, but may also cause change for a change of venue in the future. This is an election year, and this case is serving as a compass to guide the DA to her path of re-election. However, it is now when the misleads in theater end and the constitutional protections begin. The safeguards of the accused and the fight to preserve those for Trezell and Jacqueline West begin now. And I thank you.
Buenas tardes a todos. Gracias por acompañarnos a nuestra conferencia de prensa conjunta. Primeramente, me gustaría comenzar presentando a los abogados. Timothy Hennessy, el abogado principal para Sr. West. Joshua Fleshman, abogado asociado con Sr. West. Y yo, Alexia Torres-Stallings, abogada principal de la señora Jacqueline Martinez West. Fatima Rodriguez, abogada asociado de la señora West. Esta será la única vez que los abogados defensores se dirigirán a los medios de de comunicación hasta después del final del juicio. No responderemos a ninguna pregunta hoy después de la conferencia. Tenga en cuenta que hemos hablado con nuestros clientes que están al tanto de la conferencia de hoy y tampoco discutiremos ninguno de los hechos relacionados con el caso. Comentarios como estos no tienen... Perdóname. La semana pasada, el señor y señora West fueron procesados por una acusación de 5 cargos, incluyendo asesinato en segundo grado como resultado de una reunión del gran jurado. Existe una gran confusión entre los dos jurados de juicio y los gran jurados, y los dos no podrían ser más diferentes. Primero, el estándar de prueba es más bajo para un gran jurado, necesitando solo determinar la causa probable, uno de los estándares más bajos de prueba. Tampoco requieren unanimidad. La Fiscalía tiene amplia discrecionalidad para determinar proceder a través de la acusación. Este proceso carece de un papel crucial y importante del sistema de justicia. El acusado y sus abogados no están presentados durante el procedimiento y los abogados defensores no tuvieran la oportunidad de entregar a los testigos de la Fiscalía. En detrimento de los acusados, la prueba de naturaleza especulativa tiene una forma de congregarse con el más secreto de todos los procedimientos legales. Por otro lado, un juicio por jurado debe acordar unánimemente la cuestión de culpable o no culpable por el más alto nivel de prueba más allá de una duda razonable y hacerlo en juicio abierto al público. El comentario del Estado demostraremos al gran jurado es pura retórica, utilizado como garantía por reforzar su acusación desigual. Comentarios como estos no tienen cabida en el verdadero tribunal y justicia, donde 12 personas que le deben decir por unanimidad el resultado de este caso sobre la base del cargo mayor de la prueba más allá de una duda razonable. Declaraciones como la utilizada por la fiscal de distrito del condado de Kern en su conferencia de prensa tienden a evocar un halo de emoción hacia la culpable, y sea fundamentado o no, que marcha el grupo de jurados locales y niega a nuestros clientes un juicio justo. Eso extraño que la oficina celebrar una conferencia de prensa hiciera una serie de comentarios que desinformen y desinformen al público, y luego el día siguiente envía a su abogado a la corte en busca de un orden de mordaza. Esta acción no solo es insincero, sino que también puede crear una causa para un cambio de sitio en el futuro. Este es un año electoral y este caso sirve como la estrella norte que guía la fiscal hacia su camino de reelección. Sin embargo, aquí es donde terminan las trampas y el teatro y comienzan las protecciones y las salvaguardas, constituciones de señor West y señora West, los acusados. Muchas gracias. Thank you everyone for being here today.
I know you guys can't talk about facts of the case, but can we ask you questions just about what it is that you said, just for further clarification?
About grand juries in
Yeah,
particular?
exactly. So, just for like the common layperson, you
Sure.
know, can you explain the difference between finding having probable cause in order to pass an indictment and the beyond a reasonable doubt? Just could you explain that a little bit further?
I mean, generally speaking, yes, sir. Right, so generally speaking, probable cause is the standard kind of being used day to day by law enforcement on whether or not to make an arrest, right?
Okay.
That is is there a probability something here happened, okay? Beyond a reasonable doubt is like, that probably happened, right? I mean, that, I don't have my calculus in front of me, but it's the idea that, that it is more probable than not, that the guilt of this offense has been proven, right? The question is not should or not this person be arrested, and that's where we're at now. It was there enough for these charges to be brought? But the highest standard beyond a reasonable doubt, that's far off. That's so far from where we're at now. But because we hear jury, we hear grand jury, trial jury, there's this general sense to think, well, they must have proven this. This must have been proven beyond reasonable doubt. And that is not what happened. That is not what a grand jury is. A grand jury is a way to bring charges, much like how we have preliminary hearings all day, every day in the downtown courthouse. That's the same thing to get you in the same place.
Okay.
They're two wildly different things, a grand jury and a trial jury.
Will you have a prelim?
I didn't know if you wanted me to, did you want me to answer that in Spanish as well? I don't know if you. Okay. So, la causa probable es el más abajo forma de los estándares. So, por ejemplo, es cuando la policía hay un arrestado una persona, es el más abajo, lo más abajo. Y para las estándar de duda de razonable es más alta. So, por ejemplo, no es probablemente, no es posiblemente, pero es más alta de esos. Okay? Más alta de probablemente, más alta de posiblemente.
Any sense of the timeline when you guys hope to move forward with the charge? Or is it still up in the air, depending on the information you guys are allotted?
That's difficult considering the stage we're at right now, as far as what we know and need to prepare for. I do know that our position, as well as our clients, is to be vindicated as soon as possible.
Where do you guys stand on the gag order tomorrow and why?
So I can answer that in English and then I'll go back. So we are going to be joining in the request for the gag order for a number of reasons. We do not want more misinformation to be spread before the jury trial. There has been very, very few number of cases that have had the opportunity to have a change of venue granted. I believe that there was one, not recently, but I believe that it came back on the Robert Mistrial trial, I believe was one of them. And so in order to ensure that our jury pool here isn't tainted, we are going to be joining on that gag order as well. ¿Quiere que yo decir eso en español también? Okay. So, nosotros queremos el orden también porque no hay muchos casos aquí en Kern County donde hay un papel de orden para cambiar el sitio. So, yo nomás piensa un jurado de Robert Mistriel, excuse me. Entonces, nosotros queremos juntar en pide a la corte porque no quiere que personas aquí no tomen mucha información que no es correcto antes del jurado.
And there will be no prelim?
No, there won't be a prelim because that is what the grand jury accomplished. So rather than proceed through prelim, it proceeded by way of grand jury, which is fine, it's an option, but it is, to think that it is somehow superior or has proven more or means more, that's inaccurate.
When you guys say change of venue, could you just be a little bit more clear? What do you mean by that?
So if we go back to the trial that I cited earlier, that the the incident took place here in Kern County, but the attorneys were able to prove in court that a significant portion of the people in Kern County were aware of the case and essentially argued that the jury pool would have already made up their mind had they decided to stay here. Again, these are not granted often, but it is something that we may be able to do considering the large amount of coverage that this case has garnered.
So basically, it would just be arguing it in a different district type of thing.
Right. Same trial, just in a different county.
Okay.
También para en español. So, en el orden para cambiar el sitio, no hay muchos casos aquí que eso es la realidad. Entonces, nosotros estamos diciendo que es posible para cambiar el jurado porque, por ejemplo, hay muchas personas aquí en Kern County que either sabemos o tenemos una opinión de este caso. Por ejemplo, es más mejor para pedir a la corte para cambiar el county, pero es el mismo jurado.
And to clarify, are you guys saying the DA went the grand jury route for political reasons?
So, in viewing the press conference, I believe that she had indicated that they went the press conference route for some reasons that may have dealt with scheduling purposes. Although that can happen, there is also something that counsel can agree to in order to allow the prelim to be continuous. She did state that there were a lot of high-profile cases in which they have chosen to go by way of indictment. Between Mr. Hennessy and our law firm, we were thinking of a couple of our high-profile cases, and those ones have not gone by way of indictment.
What challenges does this sort of present to you guys? You mentioned you guys have had these kinds of high-profile cases, but what sort of barriers are you guys now presented with? I mean, obviously there's the change of venue. Any other challenges that you guys are sort of facing and working through right now?
I would say in comparison to other cases, and I think one of the reasons why I wanted to speak today on behalf of Mr. West is the public's response to a lot of this has made it seem like it's a done deal. Like, why would you take this case? Why would you represent this person? He was found by this jury already. And to us, that's detrimental to the defense. That's like the fundamental purpose of this is innocent until proven guilty. And people are telling me, hey, it's a done deal. We saw it on the news. We heard it. A jury found him guilty. They proved it to a jury already. And to us, that's the most detrimental thing. Because this has to be a jury of people ready to sit, listen, do their job, hear the evidence, make a decision. And if the whole community already thinks that's a done deal, no one's going to show up to take this seriously, then we've lost already. And that is the point today, is to make it clear what it is that was done and what still has to be done before you want to convict our clients.
Ujú. Y también cuando leer los comentarios de, por ejemplo, YouTube o de la media, también hay muchos comentarios que personas están diciendo que ellos están culpables porque necesitan un jurado, porque un gran jurado ya dice que ellos son culpables. Entonces, esta es la razón que nosotros piensan que esta conferencia es más importante para correctar las palabras, los estatutos de la fiscal.
What if you did the normal way, the normal trial, would you still take the case?
I'm so sorry, I didn't understand the
If they
question.
did it the normal way that they did in a regular trial, like the normal one, would you guys still defend these people?
Yeah.
Right.
They're still innocent until proven guilty.
No, I
Doesn't- yeah,
understand.
yeah, no, and it doesn't matter if that's a grand jury putting charges or a holding order at a prelim. I'd have still taken the case. I just want the ground we're working with now for everyone to understand that we're in the same place had they been held to answer at a preliminary hearing.
Sí, porque es muy raro para hacer este tipo de audiencias. Es raro para hacer este tipo de audiencias y también, like my counsel was saying, que ellos son inocentes ahora.
Can you guys confirm if this case is being worked by you guys pro bono?
It
Is
is-
that what's going on?
It is not. So we are appointed through the Indigent Defense Panel. That is a program that is run through the Kern County Bar Association. And so that is how we have been appointed to the case.
And you guys are requesting a change of venue.
I think that's something we have to discuss further and see where we're at. I think the concern is that is where we end up, and we'd like to avoid that if we could. It should stay in Kern County. It's Kern County's people. So, but that being said, I think it's something that we are aware of and paying attention to.
In establishing sort of like the timeline that you guys are going to be working with here, or even speaking to your clients as well, were you guys able to establish when exactly the West moved to California City?
I think that that's a little bit beyond the realm that we would like to discuss here today. We definitely do not mind talking procedure, but that's a little bit over what we wanted to discuss. Thank you.
You guys also said that there was some stuff that Ms. Zimmer said at her press conference that was like a little emotional, you know, tugging at those strings. Could you talk specifically what were the stuff that she said that really struck you as that?
It's not to say that this is not going to be an emotional case. However, we did believe that there was some phrasing that was used that to a lay person implicates one thing, but to an attorney or to many attorneys implicates another. When we hear stuff like we proved to the grand jury, they were convinced, they believed, that isn't the standard in which they make their finding.
Okay.
And so to us, it was to more clarify that that isn't the standard. That isn't to say that the grand jury aren't humans and that they obviously can't make up their own mind. It's just that that's not the same standard in which we know the standard to be.
And then one last question, just more of like if a person isn't a lawyer, a gag order, when is that implemented? What's sort of the standard that has to be met there for a judge to be like, yes, we're going to go forward with this?
I would say the request of a gag order is relatively routine in a high-profile case. I don't think there's anything out of the ordinary in requesting it. I think the only thing that didn't sit necessarily right with us was a press conference comes out and then they want to place a gag order. And I think to us it was like, well, we should also have our opportunity to address exactly what we've done here, how we see it differently.
Sure.
But other than that, not talking about the case, because the reason why then I think Alexia talked about this as kind of the essence here is we want jurors who are going to sit and hear the evidence, how it's supposed to be presented. Let this play out. I mean, this is one of the fundamental things our society has is trial by jury. And it needs to stay pure and be what it should be, and that be 12 unbiased jurors listening to the evidence, making a decision. The minute that starts to seep into the jury pool and things change, that's our concern. We just want to get it now. So that's why tomorrow we would agree with the gag order.
There is currently, also a lawsuit that the county has placed on the West and North for, are you guys sort of going to tackle that lawsuit as well? Are you guys going to represent them on that litigation as well? Or is that going to complicate this for you guys a little bit?
So the answer to that right now would be no. It was my understanding that the lawsuit, the civil lawsuit, is filed by the biological father.
There's another one. So the county, the West, are facing like a child support lawsuit, I believe, for the other children.
Okay.
So there's the biological one, but then there's also the one by the county.
And you're not referring to a dependency issue?
It is the dependency one.
Okay. Then in that case, we do not represent them in that particular matter. They actually have other attorneys who have also been court appointed through the Indigent Defense Program who represent them in that matter. That is not to say that we aren't working together. It's just that we aren't representing them on that matter.
All right, with that, we're good.
Okay, thank you so much.
I was
One
just
last
gonna say,
question.
should tomorrow's motion for the gag order, should it be denied? Would that change your guys' stance, or do you think it would change your client's stance on further commenting on the details of this case?
Like you mean,
Like
sorry,
public, in the beginning you said that this would be, at this time, the only time you plan on addressing media and questions regarding the case. Tomorrow, should the gag order be denied and details come out before the trial or throughout the trial, would you guys consider readdressing media at that point?
So I think that at this point, if the prosecution and the defense are going to be joining in that motion, I don't necessarily see it being denied. The reality is that whether or not it is or is not denied, it would still be in our best interest to at least just wait until the trial. We don't want to use the potential motion for change of venue as a sword and a shield. We want to be able to articulate that motion if necessary and have it granted, again, if necessary, not by our own doing. So I think that regardless if it were or were not to be granted, we would still be abiding by the silence until the end of trial.
This agency you're talking about, did they come to you or did you go to them to take on this case?
The agency.
The Indigent Defense Panel,
Uh,
it assigned us. I mean, we were available for appointment.
It did, but I will note that we are asked if we would like to take on a case, specifically Mr. Hennessy and I, and we did choose to take this on.
Sorry, just to go back again to the change of venue question, you guys did say you guys have to discuss it a little bit further as well, but what would it depend on to motivate you guys to ask for a change of venue?
There are specific factors that we have to look into, that we actually have to do research on before we could bring that motion to court. As an officer of the court, we are bound from bringing frivolous motions, and so we want to ensure that there is at least some basis for that. I will point out that as you all have been covering this case, I too have been reading everything that you folks have been producing. But specifically, I would direct you to that Robert Mistrial case. I did read an article several years ago that indicated that I guess at the time of the hearing that the court was able to establish that 72 to 79% of the county either were aware of the case, had an opinion about that case, etc. Again, these are motions that are not granted often, and so a lot of times attorneys have to go back to the cases before us to determine how something can be brought about.
I would think the sentiment from both of us is, as pleasant as this has been, we'd rather not be doing this. We'd rather not be thinking about a change of venue. We'd rather just getting ready for a case, going before a jury and trying it. I think that would be our preference. I think in this one instance, because of the unique circumstances that got us here, we wanted to make this statement to point some things out before kind of shutting it down and doing it a trial like it should be done.
Anything else?
Thank you.
Okay,
Thank you so
thank
much.
you.
Follow-up first before we start the wrestle.